straight out, huh? Yeah. You get one. You get looking for you that. Good for you. On your time, right? You can lower your heart rate. So it's a perk. Rookie shot. Up there and
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is State versus Real, and we will hear from the appellant.
May it please the court, my name is Jillian Frank with the Appellate Defender's Office. I represent the defendant, Quashan Real. I'd like to reserve 5 minutes for rebuttal. Customary, usual, reasonable, respectful, typical, ordinary, and non-alarming. That's how the Court of Appeals described the knock and talk at Mr. Real's home in August 2020. We're fortunate to have a video from Mr. Real's front door, which illustrates what happened here better than I could explain it. So before we dive in, I'd like to show the video and draw your attention to the start of the video through when the visitor is admitted into the door. Would any of us consider that interaction customary, reasonable, respectful, non-alarming? With officers cutting through the side yard, with an officer crowding the visitor and trying to follow her into the house, with the officer not even identifying himself before attempting to kick the door in? I would not. I would describe that interaction, the officer's attempt to piggyback on the visitor's entry into the home, as an unlicensed physical intrusion into the protected curtilage of Mr. Real's house. There was no invitation, implied or otherwise, for the officer to attempt to follow a visitor into Mr. Real's house. This was not a knock and talk, it was a search. and because the officer did not gain probable cause until he had already trespassed upon the curtilage, the officer was not legally authorized to kick down the door and enter Mr. Real's home. The law regarding knock and talks is well established. Knock and talks are consensual encounters. They're conducted when police do not have any probable cause. And as such, police can do no more than what a reasonably respectful citizen who is visiting your property may do. Think trick-or-treaters, Girl Scouts, salesmen, or maybe a neighbor. Someone who's acting consistent with the social norms. They can approach by the front path, knock promptly, wait briefly to be received or not, and if not invited to stay longer, leave. If they stray beyond this, it's an unlicensed physical intrusion and they're a trespasser. And if they observe something while trespassing, it's an illegal search. Here, the officers did several things that took this out of the realm of a knock and talk and turned it into an illegal search. The most significant were, first, the officer waiting so close behind the visitor at the door, and second, stepping inside of the storm door as the visitor was being admitted. Just imagine as either the visitor going to visit someone or as the person who was waiting to allow someone into your home, imagine someone behaving this way. It would be strange and frankly alarming. A normal person in this scenario would have walked up, waited a respectful and appropriate distance back, allowed the person who was already at the door to knock and be admitted or not, and then after their interaction was over, approach to have their own interaction. When the officer here stood so close behind the visitor, in fact, so close that Mr. Real and the officer both said that he wasn't able to be seen, Mr. Real was not given the meaningful choice of whether or not he wanted to avail himself to police or not. When they went even further and stepped into the doorway as the door was opened for the visitor, not opened for the police officer, he was trying to borrow the visitor's consensual entry. The officer didn't have the implied license to do either of these things. When you consent to open the door for one visitor, you're not consenting to open that door for another visitor, least of all a police officer. Therefore, it's clear from just these actions, these two actions, that the officer exceeded the scope of the knock and talk. But the officers here did other things which also didn't align with normal knock and talk procedure. They did not park in the driveway or in front of the house. In fact, they drove by the house and upon seeing nothing, drove around the block and parked on an adjacent side street next to a graveyard on the side of Mr. Real's home. They then did not approach from the front walk. You can see a little bit from this video, but also from some photos, some Google Maps photos that are in the record, that there was a paved front path that ran from the street in front of Mr. Real's house straight to his front door. They did not take that path. Then after
it appears on the video that may be a parking area. It looks like the curb is broken and that looks like kind of a gravel area.
Are you referring to the street next to the graveyard or the sort of fenced in area?
Well, the area that seems to have the fence that seems to allow for cars to park there and people to use that as an entryway or a walkway.
Your Honor, I would disagree. To me, that appears to be hay on grass, and that's partially enclosed. And regardless of whether the residents or someone could be told that they're allowed to park there, even if that was the case, That's not where an invitee to the property who had never been there before would park. It's customary to park in the front of a home or in the home's driveway.
How did the female approach?
The testimony about this is rather confusing. So,
What did the trial court find?
the trial court found that she parked in, I think, quote, the same area that the officer parked, which would be on the side street. It's, as I said, confusing in the testimony because sometimes the officer described himself as parking in the driveway or on the street. But it's clear from the video and when they later nailed it down with him that he parked on the side street next to the graveyard. So he does at one point describe her parking near him. But as I said, it's a little confusing. Regardless of whether she parked on the side street or in the front, we have no evidence to suggest that she wasn't given any type of special permission to park there. The officers conducting a knock and talk are only able to do what a reasonably respectful citizen may do, and that would be to park in front of the home. And we have no evidence saying that the driveway was full or blocked and they couldn't park there. Rather, they drove around the block and parked on the side of the house out of view from the front door.
There's an uncontested finding of fact, 18, that says that the officer detected the strong odor of marijuana emanating from the residence in a waft of air that left the residence upon the main door being opened. So we take that as true, correct?
Correct. He testified that when the door was opened to admit the visitor, that's when he smelled the scent of marijuana coming out of the house. By that testimony, and if you hear that testimony and watch the video, at the point that the door is opened, he is already only 2 feet from the doorway, right behind, he said he was right behind the visitor, which we saw that he was, and he was grabbing a hold of the storm door, stepping forward as if to follow her inside or at least move himself into the doorway to call out for Mr. Reel. So by even his own testimony, at the point that he smelled the marijuana, he was already within the curtilage in a vantage point where he had not been invited into and which was not appropriate for a knock and talk. Because he didn't smell the marijuana from a lawful vantage point, it couldn't be the basis for probable cause to kick down the door and immediately enter the home. The bottom line is that Americans have the right to control who may access their property and under what terms. At the very core of the Fourth Amendment is the right of a citizen to retreat into their home and there be free from unreasonable governmental intrusion. Specifically in this case, Mr. Reel was not able to close the door behind his visitor. We could see from the video that as Mr. Reel attempted to close the door behind his visitor, it stopped. So Mr. Reel was denied the right of being able to retreat into his own home. While maybe just one of the abnormalities of a knock and talk, like cutting through a side yard, could be permissible under some circumstances, each part of this law enforcement action exceeded the scope of a knock and talk when considered together. As such, no exception to the Fourth Amendment's warrant requirement existed here. This court should reverse the decision of the Court of Appeals and hold that the trial court erred by denying Mr. Reel's motion to suppress. If the court doesn't have any other questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. Hear from the appellee.
Are we able to keep this up?
Yeah,
by
sure.
any chance?
Okay, thank you very much. May it please the court, the Honorable Chief Justice Newby and Associate Justices of the Supreme Court. My name is John Payne. I work at the Attorney General's office, and I represent the state in this matter against defendant Reel. The issue, as has been put out, is whether or not this approach by the police officer stayed within the scope of the knock and talk and did not amount to a search under the Fourth Amendment. The Court of Appeals said this did stay within that knock and talk. We're here because of a dissent. The state respectfully submits that the majority opinion was correct. The test that we're reviewing today that was in the Falls case to determine whether or not police stay within the scope of the knock and talk is whether or not these police officers stayed within societal expectations. And their approach needs to be in a manner that is, and I quote, customary, usual, reasonable, respectful, ordinary, typical, and non-alarming. And has been stated also by our appellate courts that this is not, and by the Supreme Court, U.S. Supreme Court, this is not a fine-grained legal knowledge. This is a test that we can look at that is managed every day by Girl Scouts and trick-or-treaters. So the facts are important in this case, and the state maintains that the facts show that these police officers did not have the pretext to search this house. And if we look at these facts in total, I think it is very clear that they did not have that pretext. Let's jump to the first fact that is important, that the police officers come to this knock and talk. And I would like to tell the court this is a duplex. So there are two sides to this house. And the testimony from the police officer was that I wasn't sure that driveway that the visitor came from that you see in this video, I wasn't sure if that was a driveway or not. It was unpaved. I didn't know if it was to 1504, the next house over, or if it was to 15A. And so he said, in fact, we saw somebody drive in. You can see there's recycling on the street. They did think this was an attached driveway area, parking area. It's just as Newby pointed out, you can see that hay or gravel, whatever it is well worn. That does appear to the public as an area that somebody would approach. I would also like to say that the area that the police officers parked in is more visible to the duplex, right? If we are looking at the police officer's intent to hide, to not be visible, if you look on the record on page 47, it shows that there's a door on that duplex on this side of that road, on that paved road. Now, when you see the officers get out, they are in an unmarked car, which you can't see. That is in the record. But they're also dressed in police gear. This is at approximately 9:50 during the day. They're in black and blue gear. Even the dissent says they are identifiable as police. They have a badge on. They have a holster. They have a hip. They have a radio. These are police. Everything indicates they're police. So you see the approach that these police have when they come up is casual. They are not running. They're not racing to find that. They did not ask. They had no idea a visitor would be there. When the officer first gets it, he tries to contact the woman and he says, "How are you?" She does not talk to him. The visitor does not talk to him. He comes in behind her. She's fumbling with her phone and her water, and he says, "Take your time." He's not trying to rush her, but this is a small stoop. As you see, the officer stood within the area. There's a tricycle. Okay, he stood right in front of that tricycle and behind the visitor at 2 feet. Now, when that visitor or defendant opened that door, as Chief Justice Newby has pointed out, there was a burp and smell of marijuana. And the testimony was that police officer smelled it immediately. That is where the knock and talk ends. The police officer did not have a chance to knock, nor did he need to knock. After finding probable cause, which the Court of Appeals found there was probable cause based on that smell, and then they found there was exigent circumstances. So when that police officer smelled marijuana, and the majority said that when he's holding that door, the storm door open, that is customary. I would say that is even polite. Storm doors will fall on somebody. It will come in behind you. He was walking up to take his chance to do the knock and talk. He did not get the knock and talk chance because of the smell of marijuana. And he did not walk into the house. He did not walk into the door. And the testimony says that. The officer is very clear in saying, no, I did not do that. Even they say, the dissent says he put his toe in the door. You cannot see from that video if he put the toe in the door. Even that is after the probable cause occurred when he smelled that. All that information is incorrect. Now, the defendant did get a chance, and it slammed the door on that police officer. Police officer saw behind the door, he said his eyes were wide open, and he also saw the defendant, what he felt was trying to brace the door. And that's when they gave 5 commands to open. The defendant did not, and they kicked in the door, and they found 9.5 grams of marijuana, pills that turned out to be ecstasy and fentanyl. And he was arrested. The visitor was not. So the question is, looking at this as a whole, are these police officers within the scope of the knock and talk? So we have a couple cases that have been highlighted and cited by the Court of Appeals, majority case. The first being State v. Lupek. So in this case, in State v. Lupek, the officer went to a house. The dog had been shot. Neighbor shot a dog. Officer went to a house, and he went to the door, knocked, and a woman came out, and she smelled like marijuana. And then she was very nervous. She took the officer out. The officer came back and said, "Can I get some identification from you?" And when the officer was walking back into the house, he said he was 1 foot behind her. And over her shoulder, he could see a bong, a salad bowl of marijuana. Well, the court ruled in Lupek was that police officer had a right to be where he was. And because of that, that was a proper knock and talk. Now, the majority also looked at cases, and similar to this case, the police officer still had a right to be on that porch, still had a right to knock on that door. That was prevented when they smelled, or it was stopped when they smelled the smell of marijuana, right? The police officer didn't put that smell out there. That is something that's defendant's actions that he puts out there. If you are in your house and you open the door and it's smelling and reeking of marijuana, any member of the public is going to smell that marijuana. And you have to understand that anytime you expose yourself to that, if a police officer is there or anybody else, there are potential consequences, and that's going to reach probable cause. So the one other case that the Court of Appeals majority opinion looked at, and defendant also cites, is State v. Falls. And they did that to illustrate how this case does not rise to the same level of State v. Falls. The facts of State v. Falls are that these police officers came at night on a cold day. Remember, we're during the day, very identifiable. They ran through trees. They weaved in and out of trees. They passed a no trespassing sign. And they found defendant in the car. And the defendant, they smelled weed and saw a gun. And in that case, the Court of Appeals said this is a bit of a departure. They're not coming at a reasonable time. People from the public would not probably come at 9:30 in the dark, run through trees. The only difference, the only similarity that our Court of Appeals found, that was we came through the side yard, which I think is understandable if you remember the public thinking this might be an area where we can park, where we can come in. It's certainly visible to defendant on that side. So I think if you were to find, in this case, it's too much of a stretch to even think that these casual police officers walking up on a regular knock and talk who happen to be behind a visitor are in some conspiracy to search this house. Every other case that the Court of Appeals cites is some departure where the police officers are not in the area they're supposed to be. For example, in Justice Dietz's case in Huddy, the police officers go around the back, right? They didn't even knock on the front door. All those cases show these people are not in a space you're supposed to be. There are some cases that say, I think Rice, that says potentially you do have a right to go in the back, but maybe the front door has to be totally impeded. But people like you go to the front door just as the police officers did in this case. So I would submit to you and justices, in conclusion, for these reasons, the court should affirm the majority opinion, and the evidence does support the findings of fact and conclusions of law. And this court should find that the Court of Appeals majority properly concluded that the knock and talk did not rise to the level of a Fourth Amendment search. And if there are no questions, I will be seated.
Thank you, counsel.
Thank you, sir.
Rebuttal.
Your Honors, I only have a couple points to make. There is a limited license to enter someone's property. As Americans, this sits at the very core of our Fourth Amendment right to decide who may enter your property and on what terms. That limited license is governed by what a reasonably respectful citizen would do. Whether or not a reasonably respectful citizen would enter through the side yard here, which again, I would contend that that looks like where someone has planted grass and puts hay on top of it. But regardless of whether someone would have approached in that manner, I tried and could not think of a scenario where it would be reasonably respectful to wait so close behind another stranger at someone's front door. I could not think of a time that anyone would do that. Not a salesman. Really, you would not do that unless you knew the other person standing at someone's door. You would not go and wait 1 foot behind the person, only in the officer's own words, 2 feet from the doorway.
Do you agree that the knock and talk ended when the officer smelled the marijuana?
I do. I agree. But I believe that by the time the door opened and he smelled the marijuana, according to him, that he was already exceeding the license of the knock and talk at that point, based on how close he was behind the visitor and how he took a step forward as if to move himself into the doorway and therefore into the curtilage at that point.
So does your analysis then really turn on just how close the officer was to the visitor? I mean, if he had been a yard behind her, 3 or 4 feet behind her, and still smelled the marijuana, could he then have entered the home and searched?
I believe that's probably the case, yes. I think that here, what makes this unusual, and this is a fact by fact type of issue that we look at, here, if he had been a few feet back, that would be much more reasonable. That would be much more respectful, ordinary. I know, speaking for myself, we have salesmen that come to my door and they always wait down the stairs after they ring the doorbell. I just can't envision any circumstance where someone would wait that close to another visitor. So I believe it is a different case if he's standing several feet back from there when he smells the marijuana.
So
Could he have moved the tricycle?
I think he could have waited on the other side of the tricycle. I also believe...
So just to be clear then,
Sure.
So it really doesn't, we're not then looking at, are we, whether he put his foot in the door and all that, because that's after the point at which he had smelled marijuana. Would you agree with that?
Yes, Your Honor.
Okay.
I just believe the importance of him stopping the door from closing. Again, we're assuming it was his foot because you can't see what stops it, but it's clearly stopped on this side. The utility of that, I believe, is just to give a full picture of this encounter, and also just to emphasize the fact that he wasn't able to sort of conclude his interaction with the visitor, and then choose to avail himself to police. Mr. Reel did not lose his rights to decide whether to avail himself to police simply because he had a visitor at his door. The officer's conduct here, therefore, went beyond a knock and talk, and it was an unlicensed entry and therefore an unconstitutional search. This court should reverse the decision of the Court of Appeals and hold that the trial court erred by denying Mr. Reel's motion to suppress. Thank you.
Thank you, counsel. Support.